Hello everyone, this is Shrestha Ghosh. I'm currently pursuing my 3 years LLB course from the West Bengal State University. Well, today I'm here to share with you all a major milestone. My latest article research work on blockchain-based smart contracts has just been officially published by the prestigious Legal Service India team on their official website. Not only that, but there's also a cherry on the cake. I am incredibly honored and humbled to the esteemed editors and panel of judges of the LSI team that they have recognized my work, my research work, my article, and has awarded me a certificate of excellence for this piece. It is genuinely very, very prestigious for me to have my findings, have my very first research work, article, to be published on their esteemed platform. So thank you so much. Thank you very much. A gracious thanksgiving to the esteemed, prestigious LSI team for this incredible honor. Thank you so much. Without wasting much of your time, I would just like to cut to the chase, and we will find out about a brief overview of my article on blockchain contracts and why are we actually discussing about these smart contracts, these blockchain based smart contracts. I won't waste much of your valuable time. I'll just discuss about certain imperative elements of my article, certain recommendations, certain blueprint that I have proposed for the Indian lawmakers, the Indian judiciary, in order to safely bridge this a very apparent, evident lacuna between technology and law. The rest you will find out about blockchain contracts when you dive deep into the article. So let's get started. So my article fundamentally dives deep into the legal complexities of blockchain-based self-executing agreements. While traditional contracts rely on paper, basically paper, human intervention, human trust, and physical signatures, these smart contracts run entirely on blockchain automated code. Interesting, unique, rare, right? Therefore, in order to seamlessly integrate these blockchain-based self-executing agreements that run entirely on automated codes into the Indian jurisprudence, into the Indian legal framework, I have made certain very specific proposals of legislative amendments. Let's see some of the very imperative points. Let's see some of the very important points without which there would be no essence of my article, there would be no essence about discussing about smart contracts, blockchain contracts. So the very first amendment that has to be made is to the Information Technology Act of 2000. See, we know that India does not have a smart contract act. It has the Indian Contract Act, which deals with traditional contracts, right? But it does not have a smart contract act. So we can say that section 10A of the Information Technology Act, the IT Act of 2000, it validates electronic contracts. Now, it uses the statute, the IT Act of 2000, it gives statutory validation to electronic contracts. And Section 3 of the Act defines electronic signatures. Now, in my opinion, as per my opinion, Section 10A of the IT Act, first of all, it must be amended to explicitly validate automated code execution, and also the definition of electronic signatures given under Section 3 of the Act, even that must be amended to accommodate cryptographic keys. Now, a very simple question arises, is that why I recommend such amendments, right? Suppose a certain tier of the Indian judiciary is dealing with smart chain contracts, right? Now, we know that Section 10A validates electronic contracts or the e-contracts executed in PDF or HTML formats, right? And Section 3 defines electronic signatures. Now, all of us belonging to the legal fraternity, we all have read the realistic school of law under the Indian jurisprudence, right? The realistic school of law says that interpretation of law is absolutely subjective. It is not objective. It depends on the particular judge dealing with that particular case. It runs on the mechanism of to each is their own, and it's absolutely subjective. It depends on the judge. Interpretation can never be objective. So if Section 10A and Section 3 is dealing with electronic contracts, Section 10A is validating electronic contracts, offer and acceptance made electronically, and Section 3 is defining electronic signatures. So they are all about electronic contracts. Now, a judge may not interpret those electronic contracts and electronic signatures being basis for smart contracts, because they run entirely on automated code. These are blockchain based self-executing agreements. They are part of the blockchain technology. There's a fine line of difference between electronic contracts and blockchain based smart contracts that I have mentioned in my article. In case you dive deep into my article, you will get to know there's a fine line of difference between electronic contracts and blockchain based smart contracts. The electronic contracts, they are done electronically, digitally, right? Not digitally, they are done electronically, PDF and HTML formats. But smart contracts, they are based on executable software code, automated code, right? So that particular judge may not interpret electronic signatures and electronic contracts. That is Section 10A and Section 3 of the IT Act being legal validation for smart contracts, automated code execution. Therefore, Section 10A of the IT Act must be amended to explicitly validate automated code execution, and Section 3 must be amended to accommodate cryptographic keys. First proposed legislative amendment. Secondly, the Indian Contract Act of 1872. So all of us belonging to the legal fraternity, may it be advocates or any legal professional or even students of law, we all are very well versed with the foundational principle of contract laws, that is consensus ad idem, Latin for meeting of the minds. This is such an imperative foundation of contract laws that the absence of this principle, absence of the proper execution, satisfaction of this principle can even render the contract voidable or even void ab initio, that is from the very beginning of the contract, right? Now, this foundational principle of consensus ad idem requires clear statutory guidelines when human intent is translated into binary code, which in turn requires us to adapt to the very robust Ricardian contract model, which very intelligibly pairs legal text with executable software code. So my third proposed amendment is for the Indian legislature, for the Indian legislative department to adapt to the Ricardian contract model. Fourthly, in my article, I have strictly outlined statutory clarification, statutory guidelines for oracle liability. Why? In order to ensure clear accountability when external data feeds fail or when it feeds incorrect data to a smart contract. Not only this, furthermore, I have also addressed certain jurisdictional disputes which may arise when smart contracts fail, when a smart contract bugs out, because like any other branch of law, even this branch of blockchain based smart contracts, even it has its pros and cons. When we have a contract, there's no doubt about it that it may fail or it may bug out. So there are certain jurisdictional disputes. Now why? We know in case of traditional contracts or under the Indian Contract Act, or also under the procedural framework, the procedural guidelines, the procedural law as established by the Code of Civil Procedure 1908, specifically section 20 of the CPC says that the jurisdiction may be decided by where the defendant resides or permanently works for gain, carries on any business, or where the cause of action arises. Now, the Latin term for that is forum domicili, that is where the defendant resides, right? Now, smart contracts are blockchain based contracts. They run on blockchain technology, right? They run entirely on automated code. So there is this automated code execution. Now how will you determine what is the lex loci contractors, that is the place where the contract was executed, or how will you determine the lex loci damni, that is the place of harm? Because it's entirely self-executing contracts. It's entirely blockchain-based self-executing contracts. You cannot actually decide the place where the contract was executed, or the defendant where or where the cause of action arises, or even the place of harm. Therefore, I have also made certain recommendations of certain jurisdictional clauses that a smart contract developer must mandate while executing a smart contract, including exclusive forum selection, ironclad arbitration agreements, and also governing law selection. It goes without saying that the future of smart contract disputes cannot lie entirely on the traditional court system, because as I've already said throughout this video, that our Indian judiciary or our Indian legislative framework is till date not equipped with handling smart contracts. It is till date not equipped with managing smart contracts, enforcing smart contracts in case it fails. Therefore, its enforcement lies deeply in the evolution of decentralized ODR, short for online dispute resolution, players, and also blockchain native courts, specifically the Kleros and Aragon. Apart from all this, as I said, I'll mention certain imperative points in this video. Otherwise, if I go on mentioning many more imperative points, this would be certain hours of video, which is absolutely impossible and not at all pragmatic. So, last but never the least, the ultimate aim of my article has been to provide the Indian lawmakers and also the judiciary with a specific blueprint in order to safely bridge this very apparent and evident lacuna between technology and law. That was all. I mean, that was not all, definitely. That was just a brief overview of my article. Definitely not all the points that I have included in my article. I mean, it's a 26 minutes read. There are so many more points to explore about smart contracts. It's a very rare, unique concept. It's an emerging concept. There's no doubt about it that the future of contract laws will be smart contracts. Because in this 21st century, we just cannot be without technology, digital space, digital framework. Wherever we go, there is this wherever we go there is this digital pathway leading us to our destination. So there's no doubt about it that the future of contract laws relies deeply on this blockchain based smart contracts. Therefore, I'd like to absolutely love to hear from all your sides your valuable opinions on this evolving legal digital revolution. Please go and read my detailed article on these blockchain based smart contracts. Explore smart contracts in depth, because as I said, there's no doubt about it that the future of contract laws is going to be this blockchain technology, blockchain based smart contracts. Because it's much more transparent, it is immutable. There's no place for fraud, or even going back, not be accountable for the promises that you have made, and while drafting these smart contracts, right? So read my article, full detailed article on these smart contracts, and never forget to share your valuable opinions, views, and also critics. Any brainchild that you may have got, any brainstorm that you may have done on these smart contracts, in the comment section below. And maybe if you need any further clarifications on these regulatory solutions that I have just made in my article, in the comment section below. Again, thank you so much to the esteemed editors and panel of judges of the Legal Service India team for this incredible honor. I'm deeply humbled and honored. Thank you so much to the LSI team for giving this brilliant platform for the legal fraternity to express their views on the fields of law, branches of law that they're interested in, and thereby encouraging them, fostering them to just give better and better contribution in this legal field, and thereby paving the pathway for the development of this Indian legal framework. Thank you so much. That's all for today. Thank you all for watching, and let's keep driving legal innovation forward. Thank you so much.